Mr Milburn, you observe in your statement that prior to your taking over the role of Secretary of State for Health, a decision not to provide financial support for haemophiliacs infected with HCV had been taken by your predecessor, Frank Dobson. And so just to set the scene, I want to look at that. Lawrence, it's DHSC 00165534. It's a letter dated the 28th of July 1998 to Chris Hodgson, then the chair of the Haemophilia Society. And I think we need only look at the first three paragraphs. It says, as you know, we've been given very lengthy and very careful, we have been giving lengthy and very careful consideration to the Haemophilia Society's proposal that haemophiliacs who've been infected with hepatitis C through NHS treatment should receive special payments. The government has proceeded on the basis that compensation or other financial help to particular patients or groups of patients is only paid out where the NHS or individuals working in it have been at fault. The needs of people whose condition results from inadvertent harm is met from benefits available to the population in general. I'm sorry to have to tell you that after considering all aspects of this matter, we have decided that we should not make an exception to the general rule in the case of haemophiliacs infected with hepatitis C. Your society takes the view that haemophiliacs infected with hepatitis C are a special case because the infection comes on top of a pre-existing serious long-term medical condition. However, the same considerations apply to other individual patients and groups of patients, whether inadvertently infected with another illness or harmed as a result of another medical or surgical procedure, who can only obtain compensation if there has been negligence. And then the letter goes on to deal with seeking to distinguish the position in relation to HIV. And then over the page, we can see it's a letter from Frank Dobson. Is it right to understand that's the decision and the policy of the department that you essentially inherited?
Yes.
If we just look at DHSC DHSC 004139_025, please, Lawrence. Now, this is a briefing from Mr. Lister to the Parliamentary Under-Secretary of State, Public Health, May 2002. I don't think it looks as though it was copied to your office there from the list of recipients. But in any event, that's, I think, probably not the issue for present purposes. If we go to the third page, under the heading Michael Connaughton's request for papers from the Dobson Review, paragraphs 11 and 12 read as follows. This request was made by Michael Connaughton when you met him recently. He made it under the assumption that a detailed analysis would have been undertaken by the department. The papers show this not to have been the case. The debate was focused around concerns that such a scheme would open the floodgates to further claims. And then this. If papers are released, they will show that Frank Dobson was minded to support a scheme limited to haemophiliacs with hepatitis C, but was persuaded from this by officials and Margaret J. And then there's reference to a chronology, and paragraph 12 refers to suggested action that the minister might want to take. Bearing in mind you were yourself, for part of the time that Frank Dobson was Secretary of State for Health, you were a Minister of State. Do you have any knowledge of your own of the suggestion here that Mr. Dobson, in fact, appeared apparently supportive of a scheme, but was talked out of it?
I was completely unaware of that, until obviously I read this.
Maybe then that's an issue we'll need to pick up with others.
Mm.
Can we then, in terms of your own time in office, pick up the picture in November 1999 at SCGV 40/170_212? Now, this is a letter from Graham Ross, a solicitor who'd been involved both with the HIV haemophilia litigation and was now representing a number infected with hepatitis C. And he wrote on the 4th of November 1999 to you. He first paragraph wishes you well. Says this: I appreciate that there will be a considerable number of issues with which you will need to be acquainted, but I wonder if I may raise a particular one of pressing concern. I act for a number of haemophiliacs who are presently suing your department as a result of their infection with hepatitis C virus through contaminated blood products. I enclose a copy of a letter I sent to your predecessor with the enclosed copy letter to Stephen Dorrell. You will, of course, be well aware of the campaign in relation to this matter. There has been an early day motion, which you have signed and copy of which I attach, calling upon the then Conservative government to provide compensation. In point of fact, there are many present members of Cabinet who also strongly believe that government should set up a compensation scheme for those infected, including the motion's co-sponsor Angela Eagle MP. I fully appreciate that even though as a backbench MP one sees the strength of the moral argument, that on entering Cabinet and in your case taking charge of the relevant Department of State, that you may then become aware of priorities and issues that perhaps could lead you to take a different view. However, I would imagine that the force of the moral argument in this political case is so strong that there would be considerable sympathy and support still remaining with all those in Cabinet who supported the early day motion, notwithstanding the wider perspective that you might now have from your present position in government. If we then go over the page, Mr. Ross says, there's two significant events have happened since my letter to Frank Dobson MP. I'm not going to read out the rest of that paragraph, but he refers there to evidence given in American proceedings about the possibility of heat treatment of factor 8 products being introduced significantly earlier than it was. And if we just pick it up at towards the end of that long paragraph, he says in the last 3 lines, I make it clear that this approach to yourself is not on the basis of legal liability, but given that your predecessors have frequently put up a claim that there is no fault as a reason to not set up a compensation scheme, it is relevant to the issue in a wider context. He then refers as the second development to recent evidence to the effect that Scottish haemophiliacs did not receive heat-treated product until some time after it was available in England and Wales. Then says this: I would very much welcome hearing from you as early as possible with your feelings on this matter. I do appreciate that there will be somewhere within your office a stock letter developed by your department's officials that has been produced in varying forms over the years to anyone seeking to urge the department to set up a compensation scheme. I have an extensive collection. It would be not only unhelpful but personally insulting to me to receive yet another variation of this stock negative response. Basically, what I'm asking is that as you personally signed the EDM, that's the early day motion, that you consider taking true personal ownership of this issue, rather than, as has been the practice of your predecessors from both sides of the House, leaving it to be run by the department itself. By that comment, I do not mean to offend the civil servants who assist and advise you, but merely seeking to make the point that surely the strength of the moral issue involved screams out for a truly personal response. Anything less than given the signing of the EDM by yourself and colleagues in Cabinet would be deeply offensive to my clients. Now that's a letter addressed to you and asking specifically for a response from you as Secretary of State, in part because you had previously in opposition signed an early day motion on this very issue. As I understand it from your statement, you don't think you ever saw this letter?
Correct.
Bearing in mind it's not only addressed to you, and obviously the Secretary of State will receive many letters addressed to them, that goes without saying, but it is actually addressed to you not merely as, in a sense, as Secretary of State, but addressed to you, Alan Milburn, because of decisions or actions you'd previously been involved in, the signing of the early day motion, and asks for a personal response from you. Are you surprised it didn't actually come to your attention?
No.
Why is that?
For the reasons that you just set out in your question, which is that both if you're a minister, but particularly if you're the Secretary of State, you receive, I don't know how many, but hundreds of letters, thousands of letters probably every year. And the department has a system for dealing with them, which is that, and again, this must seem very strange to people not sitting inside the department, but just to be clear about it, a letter like that would come in. It would come into the department. It may well have gone to my private office. I don't know. I think it was faxed, actually. If I remember from, I think there's a fax sheet that you didn't allude to, but when I read the evidence, I think it's a fax.
That's if you look at the document on the screen, it's got fax across the top.
Yeah. So from memory, having read it, so it was clearly faxed to my private office. What would then happen is that my private office, and I know this must seem strange, wouldn't stick that letter under my nose. Instead, it would go into the department for consideration by officials in order that a response could be drafted. And this would seem even more strange, the response wouldn't necessarily, even though addressed to me in that rather personal way, as you allude to in your question, the reply wouldn't come from me either. And I think the basic reason for that is that it would be virtually impossible to deal with the volume of correspondence that you received as a Secretary of State. And so either Mr. Ross could have received a reply, not from me, but he could have received a reply from an official. I think what actually happened, again from memory, is that he didn't receive a reply from me because I didn't see it. He received a reply, I think, from Phil Hunt,
yes,
the minister in the Lords. And that was how the procedure worked. And, you know, I know it sounds very counterintuitive and odd to people who are listening about these sort of issues, but that's how the system worked, and it was for good reasons, which is to try to ensure that, you know, you were able to. You weren't inundated with thousands and thousands of letters of correspondence. And by the way, exactly the same thing happened with letters from members of Parliament. That the working assumption I know of very often is that if I'd received a letter from an MP, a fellow MP, that somehow I would read it, look at it, either draft a reply myself or get someone to draft it. In fact, what actually happened was the letters would come in, they would then go into the sausage machine, and the sausage machine would spew out a response. And probably I would sign, depending on who it was from, I would sign a reply to a Member of Parliament, although very often letters from Members of Parliament addressed to me would also be signed by other ministers. And so the John Grogan example that I was referring to Sir Brian earlier, I don't think that was a letter to me, but I signed off the response.
And we may come back to a couple of examples of letters to
sure.
MPs later in the day. For the sake of completeness, we don't need to put this next document on screen, Lawrence, but you're absolutely right that this was a faxed letter, and the fax cover sheet for the record is WITN 6942005, and it's got a stamp received in Secretary of State's private office 5th of November.
He must have got he must have had access to the fax number.
And then you are also right. There was a response, and it's a response from Lord Hunt. We'll just briefly look at it. It's DHSC 0006462_085. I'm not going to read the letter aloud. We can see paragraph 3 refers to sympathy and the government having listened soberly to the arguments for compensation. And then the bottom of the page, the last paragraph, refers to essentially the ongoing policy position. Only that compensation or other financial help is only given when the NHS or individuals working in it have been at fault. And then if we go over the page, Lord Hunt addresses in the first 3 paragraphs the issues that Mr. Ross had flagged up. And I think, bearing in mind your own lack of involvement in this letter, the adequacy or otherwise of that response is probably something that will need to be explored with others. So can I, however, just ask you to look at and the submission that went to Lord Hunt about this? It's DHSC 0006462_091. So this is dated the 22nd of November 1999. It's from Mike McGovern, and it's to Lord Hunt. If we look at the name of copy recipients, I don't think that includes anyone in your private office.
I don't think so. I think Mark Ferrero. Now that name rings a bell.
So I can check that.
Why don't you check? But yes, I can't. I think Mark may have been in my private office at some point, but he wasn't. You know, the principal private office people, as you'll see from later correspondence who were dealing with this issue, were people like Stephen Waring and Sammy Sinclair. So that's. I think that's probably worth checking.
Well, we can certainly check that. In any event, it is copied to a wide number of people within the department. I just wanted to look at paragraphs 2 and 3. It's really paragraph 2, but we'll look. I'll read 2 and 3. So that's Mr. Ross, and this is the description from Dr. Mike McGovern within the department. He makes a strident case for compensation to, I think that must be B, missing, paid, because of the department's significant level of culpability in this shameful history of the UK's blood industry, and plaintiff plea for a personal reply from the Secretary of State so as not to add to his extensive collection of stock letters. I attach a draft that expresses sympathy for the plight of this unfortunate group of patients, repeats the government's policy not to provide compensation, and rejects a claim of negligence on the part of the NHS. The draft does not pick up his tentative request for a meeting to discuss the issues. It's been cleared in confidence with relevant policy divisions, and a number of those are then listed. Now, it might be said the reference to the strident case and the plaintiff plea may be said to display a degree of impatience with the approach, or dismissive in some respect. Is that the ordinary way in which you would expect departmental officials to characterise these kind of issues being raised?
Well, I hope that wasn't the intent of Mr. McGovern. I think it was who was the official. And I actually, when I finally read the letter, some 20 or so years too late, as part of the pack, actually, I thought the letter was. You know, he I thought made a quite a balanced point about my signing of the EDM, for example, that he recognised that, you know, early day motions they're quite a common currency, if I can put it like that, in the House of Commons. There are a lot of EDMs that people sign, and they're a means of, I suppose, expressing concern rather than anything else. But I think he recognised, not unreasonably, that once one was in office and then you are having to weigh up these issues in a more rounded way, that you could come to a different judgment, which indeed was the judgment that I came to. So, yeah.
Now, that's the end of 99 then. Just following decision-making through chronologically, you refer in your statement at paragraph 7.9, perhaps so that others can follow, let's put it on the screen, WITN 6942001, please, Lawrence. At page 14. So bottom of the page, you refer to a Westminster Hall debate on the 7th of March, initiated by Michael Mates MP, addressing the subject of those suffering from hepatitis C, and in which John Denham spoke for the government. I've no recollection of being consulted about John's response. And again, it would have been normal for him to determine the form it should take without seeking input from me. I'm not going to ask you about the detail then of a debate that you didn't participate in, but can you just help us understand what a Westminster Hall debate was, as opposed to the kind of debate that we would see in the chambers in Parliament?
Yeah. So I think Westminster Hall debates were, I think, relatively recent innovations. I can't remember when they were introduced, and the reason that they were called Westminster Hall debates is that they actually took place in Westminster Hall that sits outside of the House of Commons chamber itself. So there are several types of debate that can take place. Obviously, there are substantive debates that take place on matters of legislation, for example, in the House of Commons chamber and obviously in the House of Lords as well. And then there could be in the House of Commons chamber, there could, for example, be something like an adjournment debate. An adjournment debate is called that because it takes place at the end of the business of the House. And in my day, the end of the business of the House was usually about 10:30 p.m. And on the adjournment of the House being relieved of its responsibilities, there could be an adjournment debate, which usually a backbench MP, it could be from either side of the House, would raise on an issue of concern, and there were adjournment debates, for example, on this very issue. The alternative to an adjournment debate is that it could take place in Westminster Hall, okay, which tended to be, I think I don't think I ever fielded, I don't think I ever replied to a Westminster Hall debate myself. I can remember as a backbench MP when I left government holding a debate in Westminster Hall. It's a smaller chamber, and therefore there were fewer participants. And it's an opportunity to air something. It's not an opportunity to, if you like, force the House of Commons to make a decision.
A description.
Is that helpful?
Yes, no. A description, I think I read online about Westminster Hall debate suggested that the aim was to foster more constructive debate than the confrontational debate that may take place within the House of Commons.
That would be unusual in the House, in my experience. But I'm sure that was the intent, and this is a serious issue. You know, it could have been raised on the adjournment, and I don't know why. Was it Michael Mates who raised it? He was a Conservative backbench MP at the time. I don't know why Michael chose to have it as a Westminster Hall debate rather than an adjournment debate at all. By and large, those types of debate actually, they weren't party political debates, whether an adjournment debate or a Westminster Hall debate. They were often issues that were, there could be an issue that was pertinent to an MP's particular constituency, or like this, an issue of real concern, where the MP concerned felt like they hadn't had an opportunity to raise that either through a question to a minister in the House or through parliamentary questions or whatever. So, yes, in that sense, they were intended to be non-confrontational, might be the best way of putting it.
If we can then pick matters up in June of 2000 at DHSC 5297720. Now, this is a note, you referred to it earlier when talking about the way in which interactions might take place within the department. This is a note from Lord Hunt, 30th of June 2000, addressed to you and to Gisela Stewart. And we can see paragraph 1 explains this note seeks your agreement to a proposed strategy for settling litigation brought against the National Blood Authority by a group of people infected with hepatitis C through blood transfusion between 1988 and 1991. The case is set for trial in October, and Council's advice is that at least some of the claimants are likely to succeed. So that's the case that results in the judgment in due course from Mr. Justice Burton the following spring. And then Lord Hunt continues, in developing a strategy, I've taken account of the fact that the devolved administrations have similar litigation pending. A settlement here would therefore put pressure on them to follow suit. We need to agree a common UK approach, and I've already met Susan Deacon to discuss options. Settling the litigation has significant presentational difficulties, given that we are refusing financial assistance to haemophiliacs infected with HCV through blood products prior to 1985. And then he says the note's being copied too, and then we have the Scottish, Welsh and Northern Irish ministers, I think they're set out.
Yeah.
If we just go down the page, under the heading Key Facts, these are as follows. I'm not going to read out the first 3 paragraphs on this page. It sets out a summary of some of the issues in the litigation. If we go over the page, however, want to pick up what's said in subparagraphs 4, 5, 6 and 7. So it says the hepatitis C virus was formally identified in May 1988. Only then did it become possible to develop a hepatitis C specific screening test, which became commercially available in December 1989. One of the questions the court will need to decide is by what date screening ought reasonably to have been introduced by the NBA. It is almost certain that the court will arrive at an earlier date than September 1991. Next paragraph, the UK was by some way the last of the major developed countries to introduce universal screening for HCV in blood. The US licensed the new test and introduced screening in May 1990, and most European countries began screening the same year. Although there were good reasons for the delay in the UK, discussions on the cost/benefits of the new test followed by trials. Legal advice is that these are unlikely to stand up to serious scrutiny in court. And then subparagraph 6 sets out some more detail about the decision-making of the Department's Advisory Committee on the Virological Safety of Blood. Paragraph 7 refers to trials taking place in 5 regional blood transfusion centres. These centres continued to use the test until it was introduced across all 14 regions in September 91. This led to a situation where between a third and a half of English blood donations were being screened for HCV from May 1991 onwards, while the rest were not. And then if we just continue, likely outcome of the court case advice from counsel, I'm not going to read subparagraph 1 of paragraph 6. That refers to an issue particular to the issues that were having to be determined by Mr. Justice Burton. Subparagraph 2 is headed surrogate testing. Just want to read that because it will feed into a question I'm going to ask you shortly. This is a test for general liver problems rather than one which specifically screens out HCV. The claimants will argue that surrogate testing would have substantially reduced the risk of HCV infection and should therefore have been introduced before the screening test became available. However, the reliability of this form of testing was at all times controversial. It was introduced in some countries, e.g. Germany, with uncertain results, was issued by the UK and others. Surrogate testing would have led to a large number of false positives, seriously depleting the blood supply, would not have made blood risk-free. The risk would simply have been less. Counsel therefore doubts a court would rule that blood not subject to surrogate testing fell below the level of safety that persons generally were entitled to expect. And then paragraph 7, if these arguments fail, the court will need to decide when it would have been reasonable for the UK to introduce screening. Counsel sees this as a serious area of vulnerability for the reasons outlined above. In counsel's opinion, those claimants infected after May 91 are very likely to succeed. The serious vulnerability back to January 91. However, it's possible that the court may take an earlier date, and counsel suggested the introduction of screening by the US in May 1990 might possibly be used as a benchmark. And then we see, under the heading Proposal for an Out-of-Court Settlement, Lord Hunt says, I've been convinced by the arguments put forward by the NHS Litigation Authority and the lawyers acting for them that we should allow the NBA to settle this case out of court. And then we see 3 reasons given: likelihood of losing, essentially, as the first bullet point, and a precedent being set. The next is negative publicity, and the third is legal costs. And then this in 9 and 10. My concern, however, has been around the terms of such a settlement. I want to ensure that there is a clear and defendable distinction between settlement of this litigation and our continued refusal to compensate haemophiliacs infected with HCV through blood products on the basis of non-negligent harm. 10. The main plank of our argument for refusing payment to haemophiliacs has been that heat treatment to eliminate HCV from blood products was introduced as soon as the technology was available. This is not true for the introduction of the screening test for HCV, and a financial settlement can be justified on that basis. However, we would start to run into difficulties if we include in the settlement those claimants infected before the screening test became commercially available. And then if we go over the page, I don't think I need to go through the detail of what follows. There's then a proposal as to how the case could be settled so as to avoid the precedent setting in relation to, amongst others, haemophiliacs. And if we then go to the final page, sorry, not to the final page, to page 6, paragraph 20, you're asked, are you content with my proposal that a settlement is offered on the following basis? And there's an offer of paying compensation to claimants infected after May 1990 and a fallback of compensation paid to claimants infected after January 1990. First question before I ask you about some of the points of detail is this. Why do you think this was coming to you as Secretary of State? Because the actual sums involved in either the initial offer or the fallback offer are comparatively small.
So I'll answer in a moment. If I can just say two things,
yes.
just ahead of doing so. First of all, that when I saw this in the pack, I had no recollection of it, first of all. Secondly, I think I'm right in saying that this was probably the first time that this issue, and indeed the issues that this inquiry is rightly engaged with, really came across my desk. So I think your question is a pertinent one. Why is it that I think that it was coming to me? I think the obvious reason was there was a case in court that the department were going to lose, and I think Phil wanted me to be aware of that, but he also wanted me to be aware that the ramifications of potentially losing were that there were consequences for the department's position as a consequence of a potential adverse judgment, which is indeed what did happen, because of course all this negotiation came to naught, and indeed there was a rather worse judgment from the department's point of view than Phil's submission to me suggests. That actually is what happened.
Now, if we just go back to page 2, we've got the summary of the legal advice which I read out. I think need to read it out.
By the way, I'm sorry, I should have said something else, which is that when I'm using these words, I'm speaking based on my understanding of now, not on my understanding of then, just to be clear. So.
Now, what we see in the articulation of the legal advice, which then feeds into Lord Hunt's submission to you as what course the department should allow the National Blood Authority to take, is the acceptance there that the court is almost certainly going to find that things should have been done
more quickly,
earlier,
yes,
and differently than they were.
Yes.
So that is clearly the understanding within the department, at least by June of 2000, if not earlier. Did that ever cause you to question whether what you'd been told more widely about there being no fault, no wrongdoing on the part of the department or the NHS, whether that might also be wrong? And should it have done if it didn't?
I can't recall that is what I thought at the time. I mean, what is now obvious in the light of both this, actually complex but pretty clear submission from Phil and from the subsequent court judgment, is that there were serious consequences in several regards as a result of the court judgment in particular, which I don't know whether you wanted to ask me about later or now, but I was going to...
Happy for you to deal with it now.
So I think that the first and obvious thing that the court judgment really did was that, this is my understanding, and by the way, I'm not a lawyer, so you'll correct me if you think I'm wrong, is that it established a different test, because the test was taking place under the Consumer Protection Act, and the test was one of strict liability, which was a different test from the tests that were being applied when fault claims were being made, as indeed they were around the pre-1985 situation and the way that people were infected both with HIV and hepatitis C. So there were different rules of the game that had been established for some groups of patients, because these were patients that had been infected with hepatitis C, but it didn't necessarily apply to people with haemophilia. So there were a number of, I think, difficult consequences, which I think had long-lasting, actually, implications for subsequent policy discussions and decisions. The first was that some people had decided to litigate, but a far larger number, or another way of putting it, some people had decided not to litigate. And so then there was an issue about, well, is that really fair? And so John Hutton, the Minister of State, was dealing with this issue at the time. And in one of the submissions, he poses the question to Charles Lister, shouldn't we do something about the fact that some people are going to benefit from being part of the litigant group here, whilst others who decided for whatever reason not to be part of the litigant group are not going to be able to now litigate because they're timed out. And I think John's view was that that was unfair. The advice came back that there was essentially nothing that could be done. So that was the first, that was, if you like, a small but important consequence. The second consequence really was much broader than that. And again, this is my understanding, and I repeat, I'm not a lawyer. This established a strict liability test, but it wasn't being applied retrospectively because the legislation wasn't set up to do that. It was passed in 87, enacted, I think, in March 88, but it therefore couldn't apply to people who had the concerns that they had about the pre-1985 situation. So that created an issue. And the third thing that it really did, my understanding now, is that because the judgment was made on the basis of strict liability, it really didn't consider matters of fault. So you could argue in layman's terms that effectively it was a no-fault compensation judgment. The problem for the department is that the policy wasn't no-fault compensation. And it's very telling, I think, that John Hutton made the correct judgment, in my view, retrospectively, that as a consequence of this judgment, that this particular judgment should be referred to the Chief Medical Officer's review of clinical negligence and his consideration of no-fault compensation. So this was a judgment that was quite, in retrospect, looking at it again, quite a significant one, I think. And then it prompted, as you know from the papers, it then prompted a big question about, well, shouldn't we be doing more for people with haemophilia and people who'd been infected pre-1985? And then you had the Brian E. Enzer submission, for example, to Yvette Cooper, setting out a range of options and so on and so forth. So I think it was I think in retrospect, it was a significant moment. Did I understand that at the time? No, I didn't, to be candid.
You're right that the judgment and that the case which this note refers to is not concerned with negligence. But one of the issues it was looking at, which would be apparent from this note, is as a matter of reasonableness, should something have been done earlier than it was. Now, that might be said to connote, whether you call it fault, criticism. It is looking at whether there are steps that could have been taken at an earlier stage to make blood safer. And as you know, the judge found ultimately that there were steps that weren't taken.
Well, particularly surrogate testing, yes.
Both in terms of surrogate testing and then the date in terms of HCV screening.
Yeah.
So my question really is a slightly more general one. The perceived wisdom, the line to take, the groupthink, whatever one might call it, for a considerable period of time by 2000 had been the department had not done anything wrong. The department had not been negligent, and you're right, negligence isn't covered by the judgment. The department hadn't done anything wrong. There was no wrongdoing, there was no fault. This might be said as a submission to make clear, or at least potentially ought to have thrown up questions in ministers' minds as to whether that received wisdom, that line they were given was right, because here you were actually finding out that there were steps that could have been taken to make blood safer earlier than they were. That might have led ministers to be more questioning about everything else they were being told, about categories who weren't of individuals who, you're right, weren't covered by this case.
Yes. I think the response, I think that we received was that this was a judgment that took place, however, on different criteria, according to a different set of tests, because it took place under this particular act around strict liability, strict product liability, and obviously the judgment was that in those terms that there was fault. But that isn't how the department or the NHS dealt with compensation claims. It wasn't under this particular act. So I think there's a recognition in, I think, subsequent submissions that this did cause a challenge to that. And then there was a question of how can we reconcile all of these things and what more should we be doing and so on and so forth. So I think it probably did beg some questions, yes.
Is it right to understand also from this submission, and we saw the reference to presentational difficulties and wanting to be able to, if we just go to the next page, Lawrence, paragraph 9, towards the bottom of the page, you got there the reference to clear and defendable distinction. So there was a concern, clearly, within the department and on Lord Hunt's part, to be able to try and hold the line and to be able to continue to say no to other calls for financial support. That's right, I think.
Yes, I think that is right. And I think there's a slightly more general point here, but an important one. I think this judgment played absolutely into this. I think what decision makers, whether they were ministers or civil servants, but maybe specifically ministers, were trying to do was reconcile really three things on this issue of compensation. The first was the obvious empathy that people, ministers, me included, obviously felt about the issue, because, as I said earlier, this was a catastrophe, and indeed one only had to listen, as I did, to some of the evidence that people have given here to understand the extent of the suffering and trauma that has been inflicted on people. So I think there was, if you like, I think every minister who dealt with this issue was hugely empathetic. You hear words about sympathy and so on and so forth, but I think that was real, first of all. I think then what ministers were trying to do was reconcile that level of empathy with two further things: the legality of the situation and the fact that ministers and, I guess, civil servants had a responsibility to try to uphold the way that the rules around how compensation was dealt with in the NHS, which was on the basis in the end about whether there'd been fault. Without slipping inexorably towards no-fault compensation. And there was a very real concern that that could happen with consequences for the NHS that could have been quite significant. And indeed, in Liam Donaldson's report, as you know, in Making Amends, where he considered these issues, I mean, I think he did so in quite a balanced way, and that he looked at the arguments for and the arguments against no-fault compensation, but in the end came down against, in part, not exclusively, but in part because of the potential costs to the National Health Service. And he talked about a figure of £4 billion, potentially, as a consequence of no-fault compensation. So there were concerns about the legality. And the final concern in all of these issues around compensation was a concern about policy. So what would be the consequences of agreeing to compensation for this, not just this group of patients, but for others, and what would be the consequences for the NHS as a whole? And of course, uppermost in all of our minds, as you're making these decisions and having to weigh up and balance this three-sided triangle, if you like, of course the interests of NHS patients as a whole were uppermost in everyone's minds. And I think this judgment came and sat starkly in the middle of that triangle. And obviously, in the end, you know, these are inevitably matters of judgment. And the very fact that my successor, John Reid, could take a different decision from me, and John's a very good friend of mine, came to a very different position. It's not something that I've discussed with him. Tells you that these were quite finely balanced issues, and I think they were all the way through.
If we just look at the language of paragraph 9, there's an issue. So if we just zoom in on that paragraph again, there's, I think, a correction to make to your witness statement. So I just want to pick that up now.
Oh yes.
So we've got there the sentence: clear and defendable distinction between settlement of this litigation, and then the phrase, and our continued refusal to compensate haemophiliacs infected with HCV through blood products on the basis of non-negligent harm. So it's the reference there to our continued refusal. That's the wording in the note that goes from Lord Hunt to you. If we go now to your witness statement, so WITN 6942001, page 15, bottom of the page. So last paragraph, you refer there to the note, but the quote is as follows: he noted the need to draw a clear and defensible distinction between settling the litigation and our continued and justified refusal to compensate haemophiliacs infected with HCV. Now, as I understand it, Mr. Milburn, and Ms. Gray has very helpfully set this out in communications with me, this is a quote from a draft of the note. The final note is in the form we've just looked at, and it doesn't include the words "and justified."
That's correct.
And that's just an error in terms of what the document is referred to.
And I think just for completeness, I think there's a lengthy email from my counsel to you setting out. I mean, this particular submission seems to have gone through quite a number of iterations. Let's put it like that. And I think the removal of the words "and justified," as I understand it, was an amendment that was made prior to it going to Lord Hunt.
Yes. So this is not really because I don't think you can assist us with this.
It's just for accuracy, really.
Simply for accuracy, if we go to DHSC 00469338_058. Although this document is not headed draft, it is, as I understand it, in fact, an earlier draft of the note. And if we go to the third page, paragraph 9 has the phrase "continued and justified refusal to compensate haemophiliacs." Now, my current understanding of the document trail, Mr. Milburn, is that someone took the decision to remove the phrase "and justified" out of the final version, but it wasn't you and it wasn't Lord Hunt.
It certainly wasn't me, because I didn't draft it.
No.
I was the recipient of it, and I don't think, from what I've seen from the email trail, it was Phil. And I think you're right, that this one must have been in retrospect, it must have been a draft, because there isn't actually a firm date on it, if you notice at the top. It talks about June rather than a specific date in June.
Can we then, if we, maybe I need to come back to this note or not, depending upon whether I am asked to ask you any further questions arising out of it. But I want to move next to a meeting that you participated.
Well, before you do that, are you going to come back to the elimination of the words "and justified"?
Well, I wasn't proposing to come back to it with Mr. Milburn. It maybe we're going to need to try and unpick it with other witnesses.
What it might imply to someone who reads and compares this draft with the final version is that somebody involved in the drafting process, probably a civil servant.
Invariably, yes. I mean, certainly. I think probably Charles, I would have thought. Charles
So, a civil servant has considered the question, looked at the words, and has thought to him or herself, it isn't justified. We can't use those words. It wouldn't be right.
I wouldn't want to conjecture. I don't.
That would be an implication.
That could be an implication.
And if it were a proper implication, it would suggest that at this stage, at any rate, there were people sufficiently senior in the civil service to be drafting a letter who, having looked at what they then knew of the facts in the light of the judgment that had been given and everything that had happened by that time, considered it was no longer justified.
I mean, who knows? Because
the reason I'm asking is this an implication? It can't be direct, of course, but it might be thought to be an implication rising out of the words used, and that I think you're going to explore with others. It's really a matter of comment, I think, rather than a question. So I'll leave it there.
Yes, and I'm very grateful. Ms. Gray has flagged this up to our attention, so we appreciate that.
Well, I thank her for that.
And the various other documents that we've looked at don't suggest the involvement, certainly, of Mr. Milburn as Secretary of State in the drafting, the earlier versions, or Lord Hunt. It may be that we'll have to go back to Mr. Lister and see whether he can cast any further light on it.
Yes, and because the implications are plain.
Yeah, there's certainly an inference that I have no doubt you'll be asked to draw from it, sir.
Yes.
So if we could then move to October of 2000, DHSC 0006245_007. And this is the meeting held in relation to the BSc inquiry report. 11th of October 2000, note of a meeting held, a number in attendance. I don't need to read out all the names, but it includes you, the reference there to S of S. It includes council involved. It includes representatives from your private office. I think Chris Kelly, you've already indicated, was the permanent secretary by this time. So a range of people participating. And then there's a heading care for people with VCJD, which I don't propose to read through. But if we go towards the bottom of the page, we've got the heading Financial Support / Compensation Issues. A meeting on compensation issues chaired by the Lord Chancellor in view of the settling of legal precedents and the possible need for mediation has been proposed for next week. Counsel JF, that's Justin Fenwick, who was representing the department in relation to, I think, VCJD claims, suggested that if compensation were offered for this kind of problem, it would be very difficult to avoid compensation for future disasters. There would also then always be louder calls for an inquiry on each occasion if this was seen to improve the compensation outcome. With haemophiliacs infected with HIV, the approach had been to invite them to name a sensible figure so that there was no criticism that the government were being mean. Another advantage of mediation was that the claimants were more likely to keep the issues confidential. The difference between the current case and the haemophiliacs was that the litigation risk with the current plaintiffs was low. In addition, the haemophiliacs were a small defined number, around 1,850, and compensation was justified on the grounds of their double jeopardy and that they were already significantly disadvantaged by their condition. Now, just before we look at a couple of other interventions or contributions, I should say, to the meeting, the context here was the heading BSc Inquiry Report Briefing Meeting was there had been the BSc Inquiry. This was, I haven't checked the date upon which the BSc Inquiry Report was published.
I can't remember,
But this is in that context,
yes.
And in the knowledge that there were various legal claims.
Yes, so I think it was the Lord Phillips inquiry into the calamity of BSE and variant CJD, and there were various legal claims, and there was also, I don't know whether by this stage we were aware of what the recommendation of Lord Phillips' inquiry was going to be, but there was a recommendation, if you remember, about providing additional help, support, care packages for people who had become victims of variant CJD. So this was to discuss that.
And then paragraph 6 then refers to use. S of S asked whether providing compensation in this case would impact on the current hepatitis C litigation. And that, I think, again, is a reference to the litigation we were discussing a few minutes ago. JF, Justin Fenwick, indicated that there were still arguments about duty of care to be resolved and that the NBA might not lose the case. The critical difference was that negligence or causation was still to be determined in the HCV case. The handwriting, is that your handwriting?
That is actually my handwriting.
In that case, can you help us unpick what it says?
Yes, quite. Talk about doctor's handwriting. It says through EG ex gratia payments. And do you want help on the previous page?
Yes, please. Now that I know it's your handwriting, yes. So it's bottom of the page. We can just zoom in on the last two paragraphs now. Legally, there was little likelihood of a...
You got the first word, I couldn't get it. Legally, there was little likelihood of a case for compensation against HMG being won.
Okay.
And I think the reason that this is actually quite unusual, in fact, from memory, I think it's the only time that it happened where someone from my private office, in this case Stephen Waring, came to me with the note, and I think if you go to the top of this...
Yes, handwriting, top left-hand corner.
To the left, he says, Secretary of State, since this note is, quote, for the record, can you take a look to see if you are content? And I guess I wasn't content because I didn't think that it accurately reflected the content of the meeting. It wasn't trying to change anything, it was just trying to capture what I'd actually heard in the meeting.
And so the handwritten additions in your handwriting it's not a later comment, it's you adding things that you think were discussed in the meeting?
Yes, exactly so. Now, I've got no idea, because I haven't seen, because you can see at the top, it says draft. I've got no idea whether Stephen took those comments on board. I'm sure he did.
So if we go back to the second page, it would appear from the contribution you make recorded at paragraph 6 that the concern about precedent setting for hepatitis C was, if not foremost in your mind, at least prominent in your mind.
I think it was there in my mind. I don't know whether it was prominent, but I was aware because... Just go back to the date again.
It's the 11th of October 2000.
So this would come reasonably hard on the heels of the submission from Phil Hunt?
The submission from Lord Hunt had been June of 2000, so yes.
Yeah, so that must have lodged in my memory, and I wanted to understand, I guess, to use that awful phrase, what the game of consequences was here in terms of if we agreed, as we did agree in the end, to a form of ex gratia payment, what the implications might be.
And then if we look at paragraph 7, we have the contribution from the Permanent Secretary, Chris Kelly. PermSec noted that this presented as a particularly horrendous case caused by feeding people infected material. Secondly, people feel they were misled by a government who did not make all the facts available. While this could be setting a precedent, it might be a precedent which ought to be set. Before I ask you about the two particular points that the Permanent Secretary made, how, in your experience, how unusual a contribution is this, a Permanent Secretary saying maybe we should be setting this precedent?
Well, Permanent Secretaries are human beings too. And I think, I can't speak for Chris, but I'm sure he felt pretty viscerally what he expressed here. You know, permanent secretaries are there to they're there to provide advice and guidance to ministers as well. They're officials. I mean, just because they sit on top of the department doesn't mean that they shouldn't somehow be able to express a point of view. And by the way, in my meetings, I tended to like people who expressed a point of view. And that's what Chris did. But he obviously felt very strongly about the issue with very good reason, if I may say so.
Now, both the observations Mr. Kelly is recorded as having made there might be said to be applicable more broadly to those infected through blood and blood products, caused by feeding people infected material, caused by giving people infected blood, and then people feeling misled by a government who did not make all the facts available is, I think, certainly a theme that the inquiry has heard, but the inquiry is not hearing that for the first time. Did the closeness of the comparison between the awful thing that was being considered here, this position of those infected with BCJD, and the position of those infected with hepatitis C or indeed HIV, did the proximity of those cases occur to you? The fact that these points could be read across?
Well, there were two awful things, weren't there? There was variant CJD, and the fact that people had eaten infected, as it turned out, infected material refers to infected meat. That's what it refers to. And there was the awful thing that had happened to people who'd been infected through blood. So there were two awful things. I guess if you slightly move on, down, then I think the distinction that came to be made was about this, that everyone, me included, was well aware of the harm, suffering, and indeed some cases the deaths of people who had been infected as a consequence of blood. I guess the difference between variant CJD and Hep C in particular is that with variant CJD, it universally was a death sentence. And of course, that isn't in any way to belittle what happened to people, because too many people died as a consequence of receiving infected blood, of course. But thankfully, not everyone did, and thankfully, there were some treatments available that helped some people. And that's good, and those treatments have got better over time. That wasn't the case with variant CJD. With variant CJD, if you got it, you died. It was pretty straightforward, except it wasn't. It was a pretty gruesome death. And the period between getting it and dying was remarkably short. And of course, at the time, this was all emerging evidence. This was so new and such a shock, and we were having to explore what could this mean, because no one knew at this point how many people were going to be infected with variant CJD. Was it going to be tens, or was it going to be hundreds of thousands? I mean, tens as in single units, and hundreds of thousands of people, but the facts seem pretty straightforward. You got it, you died. Invariably, it was young people. It was gruesome. And the period on average, I think I'm right in saying, between being being detected with the infection of variant CJD and dying was 13 months. And it could be as short as 6 months. And obviously, these are very fine distinctions that are being made, and they're difficult, obviously, to express here in particular. But there was a distinction.
And if we just pick up a couple of further paragraphs, so we see paragraphs 8 and 9 are Mr. Fenwick outlining possible approaches here to the provision of assistance to those infected with VCJD.
Yeah.
And then paragraph 10, Secretary of State felt we needed a paper to make the argument for some form of compensation, making clear the pros and cons, making explicit the read across to HCV and any issues of precedent, not only for this department. The realistic option seemed to be a flat rate ex gratia payment to a trust fund. This would then indicate the need for a narrower package of care without hardship elements. He felt the trust fund should be promoted as the best solution. And then there's a further contribution from Mr. Fenwick. And then if we go to the top of the next page, Secretary of State stressed that there was a strong moral imperative here, that he wished to be seen to be taking the initiative, and that he needed a form of words for the date of publication. I think that's anticipating the date of publication of the BSc inquiry report,
Yes.
I suspect, but
Yes.
I'll check the dates, Mr. Milburn.
I think that's probably...
Which went as far as possible without prejudicing the financial outcome. A paper was needed on this. So that, I think, is the discussion on compensation recorded here. Perhaps just before we leave this document and indeed break for lunch, there's then a heading medicines.
I think just one
Yes,
final
of course.
point, sorry, just to make the obvious point, I suppose, which is that one of the other differences, of course, is that this was an issue for the whole of government in the sense that the blood issues were clearly issues for the Department of Health. But here, this was something in terms of responsibility that spanned departments, not just the Department of Health. It wasn't purely a health. In terms of causation, one could argue that it wasn't really a Department of Health causative issue. If it had been caused anywhere, it had been caused by the consumption of meat that people had been assured, including by ministers, was okay, not from the Department of Health, just for the record.
Just before we look at the heading medicines, as I said, this meeting is the 11th of October 2000, and I'm told the BSc inquiry report was published on the 26th of October 2000. So this would fit with you having had advanced receipt as a participant of the report, or perhaps some aspects of it, and discussing it.
Yes, possibly, and maybe we'd even been given, I don't know about this stage, maybe we'd even been given a heads up about what was going to be in the Phillips report. I don't know.
I just want to, so that we don't have to come back to this document, look at what's said under the heading medicines. There's reference, so as I understand it, there is a concern here about whether there may be implications for the safety of medicines. I don't need to ask you about the details of that. Paragraph 15 records you saying SOS felt that the lesson from the inquiry was that if we can't give concrete assurances on safety, then we must tell the public, but with full information on the potential risks, i.e. of vaccination programmes suffering, and then you asked for more information on that. And then the last paragraph, paragraph 17, Secretary of State made clear that we must have a policy of maximum openness on this issue. Is it correct to understand from this section, in particular paragraphs 15 and 17, that your approach recorded in this meeting is if there are any risks to patient safety from in relation to medicines, vaccinations, then the public have to know that. There has to be complete openness, even if there is a potential public health consequence in the sense of people deciding not to accept vaccines.
In this case, yes.
Yes.
So, but I just want to nuance it because I know this question of openness is an issue, and I just want to just be balanced in terms of my views on this. In this case, this was very, very difficult because the question at root was that most vaccines were grown in material which potentially, we didn't know, could have been infected. That was quite a big thing, including, I think, childhood vaccines. I can't remember whether they were included or not. And that was obviously, I can remember a sort of tremor going down my spine when alerted to that, because the consequences were obviously potentially enormous in terms of what that meant then for the vaccination programs that we had, which, were the biggest and most important success story in dealing with so many public health issues. And there are obviously enormous risks about going out and saying to the public, there's a problem. Because what you didn't want to have happen is people not get their vaccinations, because we know what happens when that happens. So I wanted to be, if we were going to go out, I wanted to do so in a way that wouldn't imperil the vaccination programme, first of all. And I think that was right. By the way, I think the public did have a right to know about this. But there were occasions when, so I guess I was on the side of the angels in this case. There were other decisions that I took which weren't for maximum openness. And I'll give you one rather difficult example to talk about, which is after 9/11 and the terrorism attacks in the United States, in New York, we had to activate our plans for how we would potentially deal with a chemical or a biological attack. We didn't know anything, but we were erring on the side of caution. And without going into too much detail about that, I didn't feel, and I can remember debating this with myself, I didn't feel that it would be right to go out to the public to say there's a risk that you ought to know about in terms of chemical or biological terrorism, because we didn't know. You know, we barely knew what had happened in the 24 hours after 9/11 had happened in terms of that particular incident, never mind what else might be in train. And so, and the reason that I felt that it wasn't right to do that, although there was some visibility, because I think people could see that there was some activation of emergency planning taking place on the streets of London, for example. There were guys in their big biological hazard suits and so on and so forth. But what I was really concerned about is that it would cause an enormous public scare and enormous public fears that may well have been unwarranted. I don't know whether I was on the side of the angels there or not, but for that reason, I think these issues around openness, and I know there's always a presumption that openness is good, they're often very finely balanced judgments. And I think, finally, I think nowadays, the presumption around openness is probably far greater than it was in my time, and certainly greater than it was in the 1970s and 1980s. You know, we're in them. People say we're out of the COVID pandemic. People ought to look at the statistics to realise that we're not. But people have become very used to the openness on the part, for example, of advisors, SAGE, you know, publishing its minutes, you know, ministers and CMOs doing press conferences, and so on and so forth. That wasn't really the state of affairs 40 or 50 years ago. So I don't want this to be misread and interpreted in a particular way. Is that the only point I'm making?
And if I might suggest to you, the difference there might be between the scenario you described where you were not in favour of openness may be that realistically there is not much an individual can do on their own account to avoid the risk of biological terrorism. But if you're talking about the risks of medical treatment, whether it's medicines, vaccinations, blood products, those are decisions that it is the right of every individual to take for themselves on a fully informed basis.
Perhaps, but one could construct an argument, I think, and this is not the side I came down on in terms of this debate about, you know, should you be completely open with people about the prospects of further acts of terrorism. You could construct an argument that actually individuals could take action. They could decide to leave the country if they were able to. If what they were hearing from ministers was that, oh, London is about to come under attack. So I get the point, but I think the real point here is that around questions of openness, they're very finely balanced judgments that one has to make. And it's not always as straightforward, even as this note suggests that it might be.
So we've made inroads into the lunch hour. I'm going to move to some different documents next. So if we could take a slightly late lunch now.
Yes, well, we'll take a lunch now and come back at 2:10. 2:10.